All right, so we are here today to talk about three common types of estates and three different types of differences in estates that planning people usually don't think about when they say, hey, I just need a will. So I want to thank everybody for tuning in to today's first series of planning videos that we're going to be doing. So we figured that while people are locked in their houses in Pennsylvania here where we're broadcasting from, we are under a stay-at-home order. So as you can see, I am broadcasting from my secure underground command post, not meaning to get in on any radio host's technical trademark there. But we are underground, and I'm in a nondescript townhome somewhere in Bucks County right now. But I'm very excited to be giving this little bit of a talk on what are the planning things that we need to be considering. And certainly, first thing people think when they think estate planning is, well, I need a will. And absolutely, that is absolutely 100% correct. You need a will. It is the most basic planning document for your estate. It's not necessarily a live document. We have other documents we'll talk about at a different time. A power of attorney. We'll talk about living wills. All those are good documents. But today we're going to be talking about wills. But guess what? Wills don't do everything all the time. Because we have two types of estates we're going to talk about first. And I am looking down at my notes because I need to be prepared. Whenever I speak, I'm usually always speaking off notes. I'm not very good off the cuff, but you can see, so it's going to be a short video right now. So we've got our probate estate and our non-probate estate. So, well, what the heck does that mean? Probate versus non-probate. So I'm going to define this exactly the way a lawyer defines it. The probate estate is everything that's not in the non-probate estate. Oh man, what do you mean by that, the non-probate estate? Well, your non-probate estate is everything that passes outside of your will. So there's a lot of stuff that falls into that. So let's say you're married and you own your house with your spouse. Well, usually you own that as husband and wife, or the other way that we say, and here's the law school answer. The law school answer is we own it by tenants by the entireties. Ooh, fancy word. Just means you own it by husband and wife, which means when you pass on, the surviving spouse gets that piece of property. So that's called marital property or tenants by the entirety. That is a non-probate item. Very important to understand that. Well, there's a whole bunch of other stuff like that. You may have a joint bank account with what's called rights of survivorship. The and on your bank account sometimes. That is a really good way sometimes of avoiding probate. We hear that, and that's not a very important concept, at least in Pennsylvania. Other states it could be. Pennsylvania, avoiding probate's not that hard a process because you still have to administer the estate whether you go through probate or non-probate. Again, topic for another video. Other types of things. Life insurance. Well, life insurance is a contract. So when you pass away, there's a contract. A company has to follow the contract and give the proceeds to whoever you put in that contract. Well, what about IRAs? IRAs, non-probate, because you usually specify a beneficiary. So we have all these types of non-probate property, joint accounts, marital property, life insurance, annuities, retirement accounts. These are all things that even if you put them in your will, most of the time they're going to pass outside of that will according to the instructions that you leave in a contract. So these are, and I just got a great question from my friend Chuck Jonas who's watching this. He's an attorney here in Bucks County. He's asking if we get CLE credit. I wish I could offer that. Talk to PBI, Chuck. Maybe they can get some post-mortem CLE credit here. But we're doing the best we can right now talking about estates, and we just went through what the difference is between the probate estate and the non-probate estate. Well, a lot of people hear non-probate estate and they think non-taxable. Wrong. Your non-probate assets in many states, and Pennsylvania being the one I'm most familiar with, a lot of your non-probate assets are still in your taxable estate. So here's a great example. You leave an IRA to a child. In Pennsylvania, that IRA, if you pass, if you're over age 59 and a half, I think it is, something like that, if you had access to those funds without penalty, well then in that case, that IRA is going to be taxable for Pennsylvania inheritance tax purposes. Now, very important also, when we're talking about these types of taxes, there is Pennsylvania inheritance tax, there is federal estate tax. Now, the federal estate tax has been changed a lot in recent years, and it doesn't apply to very many people anymore. It's exempted for about $11.5 million per person at this point. A lot of people are exempt from federal estate tax. So just remember that when we talked about probate, non-probate assets, then we get into taxable, non-taxable assets. Non-probate assets can be taxable. IRAs, annuities, those are non-probate assets which can be taxable. Most probate assets are in fact taxable, but you have to go through the Pennsylvania inheritance tax return, and you get deductions for, well, if you owe people money, you get deductions for that. There are deductions for your last expenses. There are deductions because, well, lawyers wrote the law, for your legal fees, of course. So you get a deduction from your inheritance tax on that. So we just went through that. So you have a taxable estate and a non-taxable estate, a probate estate and a non-probate estate. And then we just touched on a little bit earlier, we talked about the federal, your federal estate and your state estate. Yours under state law, and in my case, Pennsylvania for most of my cases. So in that case, those are different estates as well. A great example, under Pennsylvania law, life insurance proceeds are not included for Pennsylvania inheritance tax purposes. They're not taxable for that purpose. But if you're totaling up your whole federal estate, life insurance is actually, if you controlled the life insurance policy and you named the beneficiary, that's going to be included in your federal estate. And again, this is only going to be a problem for most people if you are in that very wealthy range. If your net worth is over $11 million, then you may have a federal estate problem. And, we're happy to talk to you about planning around those things, especially if you own a business, if you own large investment assets, if you own some real estate, those types of things we can. But for the average person, we're not going to have to deal with federal estate tax purposes. But many of our clients have an illiquid estate. Now that's something that can be a problem. What does that illiquid mean? Well, some people, and I just worked with a lovely dear old client down in Central Bucks. She has a large piece of real estate that's been in her family for 4 generations. She lives on this real estate. She cares very much about this real estate. And she also put a conservation easement on this real estate. So it can't be sold for development at any time in the future. She doesn't have a lot of cash. She doesn't have a lot of investments. Well, if you don't have a lot of cash and you don't have a lot of investments, you still have a tax bill in Pennsylvania that you're probably going to have to pay if you're leaving it to your children. That's about 4.5% of the taxable estate. So what are we going to do in that situation? Well, the heirs are either going to have to borrow against it or sell that asset, liquidate it, turn it into money in order to pay that inheritance tax. So that's another thing that you need to consider when you're making an estate plan. You can say, it's very easy to say, I want my kids to have everything. But sometimes we have to consider how they're going to get everything. And knowing how they get everything, and the first question you need to know is, how do I own it? And how can I turn that into money? Or do I want to give it to them as a solid gift? It's called an in-kind gift. Am I going to give them the actual thing? So that's a great introduction to estate planning. We're going to talk about some of these other concepts later on in the week. We're going to talk a little bit more about special needs trusts. I have somebody who asked about, well, I have somebody who needs to be taken care of after I pass away because they can't take care of themselves. We're going to talk a little bit about that. We're also going to talk a little bit about testamentary trusts. So what's a testamentary trust? It's a trust you put in your estate. Say you have children and when they turn 18, you don't want them getting their entire inheritance all at once, going off, buying that Corvette and taking that vacation and not having anything else for the rest of their life. So we'll talk a little bit about how that works as well. So if you have any questions, please put them in the comments. I'll be happy to answer them. If you don't want your questions to go out publicly, direct message me. I'm happy to answer them. We have a great team at my law firm, High Swartz. We have some of the best estate planners, I think, in all of southeastern Pennsylvania. I'll even go as far as to say all of Pennsylvania. We have a great team of people. I'm happy to answer any questions that may come up for you guys. And thank you very much for tuning in today. Share the video if you think it was worthwhile, and we'll talk to you very soon. Have a good day. Bye-bye.